Okay, welcome everyone. So this is the fiber optics session. We are going to cover three topics here: fiber optics, elevators, and communication tower contracts. All of the contracts where Cora is going to lead with all of these. Dave the Dean, who had originally been invited to host, had a family issue, and so we've invited Cora to take his place and to relieve us here, and that's just great. If anybody has any questions as we go along, just put it through the Q&A. The session from this point on gets recorded, and we basically post this to the YouTube website. So you can come back and visit it and share it again with your Strata Corporation. And we'll try to keep questions to the very end. Again, the sessions are 30 to 40 minutes long with questions. So if you ask any questions, just try to keep your personal information out of it. Tribe Management is our sponsor this week, and thanks very much for their support of the programs and for the education programs. And just a little reminder that we give you general information here. It's educational. There's no way we could give you any specific legal advice, as there's just too much information that would be needed to be able to assist further. But if you require additional information or have any questions, just let me know. Give us an email and we'll be happy to get you a referral or help you out with someone. So Cora, we're all over to you.
Thank you so much, Tony, and I'd like to thank CHOA for putting on this webinar. It's incredibly important to the community, the Strata community. And what I would like to talk about today is a number of things, and I'll just summarize them for you. I'd like to go through the principles of contract, deal with some conflict type issues, and to look at three different types of contracts, as Tony has just pointed out, which is fiber optics and the elevator contracts and communication tower type scenarios. So the basics of contracts, I would just like to highlight that contract review and drafting is an art. It's also a legal service, and it's relatively straightforward as long as you follow the basic principles. You need to have offer acceptance, consideration, certainty of terms, and dispute resolution clauses. As long as you have all of that, you've got a valid contract. One proviso is that an agreement to agree is not a contract, and you want to make sure that you're standing on solid legal ground. So in light of that, I'd just like to go through a few of the basics. When a contractor or a consultant is engaged to provide work or services, then a contract of some form exists. It could be verbal or it could be in writing. You're going to hear me say over and over and over again today that the contract should be in writing. The contract binds the parties to a particular scope of work. It could be general, it could be specific, it could be discretionary. So there's a number of different ways that you can draft the contract. We do recommend a written agreement for all contracts for goods and services. Doesn't matter how large or small. Written agreements will help the Strata Corporation to ensure that there is a very clear understanding as to the parties' rights, duties, and obligations, and to deal with any costs or dispute resolution. Again, I'd like to highlight that no contract is too small for a written agreement. Just because the amount is small doesn't mean that the contract is simple. It could be as complex as a very large contract. So it's not the financial number that dictates the contract itself. It's the nature and the extent and the circumstances of the contract itself. So we can have a number of different kinds of contracts. One of the contracts that everyone is familiar with is the repair or remediation type contracts. We call them CCDC type contracts. They can be fixed price, they can be stipulated price, unit price, or cost plus. So you really have to ask yourself, how am I dealing with my contract? What works for me, and which contract should I choose? We also want to make sure that we ask ourselves who is going to be involved in overseeing the work. Is it going to be a certifying consultant, such as an engineer, or will it be someone else? You want to be asking yourself that question before you sign the contract. You want to know what the terms and conditions of that contract are so that you know exactly what everybody's rights, duties, and obligations are. We can have emails going back and forth, and you ask yourself, does this constitute a contract? It's possible that it could. It depends on whether or not you've satisfied all of the requirements for a valid contract. Again, offer, acceptance, consideration, certainty of terms, and dispute resolution. Now, if you haven't got all of those things, you may not have a complete contract. If you don't have a complete contract and you have an oral agreement, then the question is that really a contract? Does it rise up to that level? And if it doesn't, then you might be into a situation where you're dealing with quantumariate, which is pay for services, or unjust enrichment. And then, of course, you're into the realm of uncertainty, and you may not know what you have. And that's when the lawyers win, because you'll typically have to bring a lawyer in order to resolve the situation. Our argument is mitigate against that by having certainty of terms, pay for the contract itself, and minimize the risk of the involvement of legal counsel in order to deal with the resolution of whether you have a contract and what that contract means. There's always a question regarding who bears the loss if a contract lacks specificity. As I indicated earlier, certainty of terms is one of the requirements for a valid contract. And so then you ask, to what extent, if we don't have a valid contract, is the strata corporation exposed to liability for losses? Now, if the contractor doesn't perform their scope of work and there's no written agreement talking about what happens in the event that there's a default, then the question becomes, where does the strata corporation stand? Is it on solid legal ground? Who will pay? How do you determine all of that? Will we have to bring a third party in to resolve it, such as an adjudicator or a judge? And will we need to hire legal counsel to assist us with that process at significant additional cost? The other thing that you have to bear in mind is there could be exposure to liability if the insurer is exposed to the loss as well. For example, if there is a flood during plumbing repairs, what happens with your insurance? Is there coverage or is there no coverage? Has there been a right of subrogation properly put into place? Is the insurer satisfied with the results? So if there's uncertainty, we don't know the answer, and that's why you need to have a contract to make sure that these elements of uncertainty are eliminated or mitigated against in order to reduce the risk. So if the strata corporation doesn't have a properly written agreement, then you ask yourself, does the contractor have liability insurance? Have you done your proper due diligence in your investigation? And if, as I pointed out earlier, the insurance provider can't subrogate because you don't have that proper insurance policy in place, in other words, they can't go after the other third-party contractor for the loss, then essentially they're going to be out of pocket. That's not going to make your insurer very happy. And at the worst case scenario, and this has actually happened, you might find that the insurer refuses to renew its insurance with the strata corporation. There is a significant prejudice to the strata corporation in such circumstances. So you always want to do your due diligence. You want to insist on that written contract, and you also want to insist on getting proof of liability insurance from those that you're contracting with to ensure that all of these issues are mitigated against regarding loss or damages to the extent you can. We know that you can have signed quotes. We know that you can have oral agreements. And it may even be that you have sufficient specificity to qualify as a contract. But they're not good contracts. They've never been good contracts. They will never be good contracts into the future. So we do not recommend that from a legal perspective. You need to make sure your contracts are addressing a number of different issues. What's the scope of work? What work is actually being done? How much will the parties be paid? What about cost overruns? What happens if there's an extra? That means the contract price goes up. So you need to ask yourself, how do you deal with those particular situations? Do you have the authority in place to make those additional expenditures? If you don't, then how do you resolve that particular issue? Strata corporations always need to have proper approvals and mandates in place, in the absence of which there's a question regarding whether or not you even have the ability through the strata corporation vehicle to legally proceed with the contract that you have in place. You might find yourself in a situation where the contract's valid with third parties due to the indoor management rule, and then who is exposed if the strata corporation isn't? What you don't want to find is that you're in a situation where individual council members may be asked to bear that loss. So what happens if something goes wrong? And invariably, particularly in large contracts, things do go wrong. And that's why we have a wealth of legal cases. So the best thing you can possibly do for yourself is to have that contract in place to ensure that if something does go wrong, then everybody knows how we're going to deal with that downside. Do you have the benefit of a warranty? Have you made sure that you've complied with all the terms and conditions of the warranty? Have you placed the appropriate people on notice? And have you diarized the warranty dates to make sure that nothing is missed? There's a number of issues with respect to warranties. And if you don't strictly comply with the terms of those warranties, you might find the warranty is void. You might find if you go in and do work without following proper protocol, you voided the warranty. There's a lot of risk and issues there as well, so be careful.
Cora, I said I was going to wait till the end to jump in, but I've changed my mind. One of the provisions, which I think is a little bit of a detriment for strata corporations in BC, is that strata councils are basically held to the standard as volunteers. And so if the strata council really doesn't competently proceed with this, or there's an omission, or there's a loss, and we've seen a number of losses in construction over the years where hundreds of thousands of dollars were essentially squandered because of bad decisions in contracts, the council members are pretty well insulated from suits. And that's one of the benefits of the legislation, but it's a bit of a downside because it also doesn't hold people to act prudently and with reasonable function. But it doesn't prevent a group of owners from suing a strata council, does it?
Yes, and I think that's a really good point. There is some excellent protection to council members against being sued and indemnification provisions and that kind of thing. However, there is a major concern that notwithstanding all of those protections that are built in, that does not insulate them from a claim by a group of owners or by an owner, for example. So in the event that that action is taken, the question always becomes, to what extent are the individual council members protected against the claim? The major part of the cost of a legal claim is the legal costs of defense. So you don't have any ability until you know what the outcome is going to be to deal with that. You don't know how much the costs are going to be. So in the absence of appropriate insurance, directors and officers liability insurance, for example, where the insurer for the strata corporation responds on behalf of council members to pay for those kinds of costs. You might have those costs paid for pending resolution of the claim itself. But what happens if the claim's unsuccessful? Then it could be that there's a requirement by the individual council members to repay those defense costs or to pay for the costs of any liability at the end of the day. So that remains to be seen. That's an outside risk. So how do you mitigate against that risk? You mitigate against that risk by having proper indemnity provisions in the contracts, by making sure that you have detailed contracts with terms and conditions that meet and rise up to the standard or the level of the proposed agreement or contract, and stipulate or lay out the duties and obligations of the various parties in that agreement to make sure everybody's clear on what they have to do. There's a lot of confusion on oral agreements because nobody really knows what they truly mean and what the scope and the extent of the contracts are. So a properly written agreement will really get you a long way in a strata corporation context to helping you to mitigate against the downside, which is somebody taking a run at you. And if they do, then insulating you or giving you a shield from the related liability and the costs. So let's talk about some basic contract requirements. For example, who are the parties to the contract? I regularly see, since we do a lot of litigation, errors made on the names of the parties to a contract. So you ask yourself, who am I contracting with? Is it Joe Blow or is it Joe Blow Inc.? Is it a subsidiary with no assets? So you're going to, of course, can't get blood out of the stone. What is the nature of the contract? Who is a party to the contract? And have they all been properly named? That's really a starting point. One of the principles of contract law is only parties to a contract can sue or be sued. So if you're not a party to the contract, or if you don't know who all the players are, then you might be missing out on some of the really basic components of a contract. And we see a lot of errors on this side. So what's the scope of the work? Well, this is easy. What are we doing? We're doing an elevator replacement. So what's the description of the elevator replacement work? What are the drawings and specifications required? What are the manufacturer's specifications and industry standards? Have we fully investigated all of those? Have they been incorporated into the contract? What's the price or the cost for doing this particular work? Are there service costs? Are there material costs? How are they going to be paid for? Are they extras? And how are we identifying the revenues? Have we fully negotiated all of the items? Do we have to satisfy the authority having jurisdiction by getting appropriate permits to do the work? Could be electricians that are required, electrical permits, building permits, could be a number of things depending on the nature of the project and the scope of the work. Have we addressed all of the insurance and liability questions? There's a number of other things you definitely want to do when you're drafting a contract. It is, as I said, an art. So you want to look at the schedules. What's our time frame? What are the details of the work itself? Is it going to be done in phases? Is it going to be done otherwise? How's it going to be managed? Who's involved? Who are the players? What happens if there are deficiencies? What happens when we're addressing the payment schedule? Has the payment been made on time? Do we have a payment certifier? And what are the terms and conditions for late payment? Have we got our indemnities and warranties addressed and insurance in place? And what's the status of WorkSafe BC? Because if you've got premiums that are owing by a contractor and they haven't been paid, it is possible for the Strata Corporation to have to pick up those costs. So you always want to do a WorkSafe BC search to make sure there's no funds that are in arrears. Conflict of interests are something that come up all the time. They come up in the context of a strata council situation. They come up with corporations of any kind. They come up in society boards. The rules and regulations governing these are not substantially different. If a council member has a direct or indirect interest in a transaction or contract or a matter, then that council member has a duty to make disclosure, full disclosure and prompt disclosure, and that should be recorded in the minutes, or it should be somewhere where it can be accessible. And then that particular council member is not to engage in conversation unless asked to stay and provide information, and needs to recuse themselves in the event that the vote takes place. So in that scenario, a person that has a conflict, and it's very broadly defined, should follow those steps to ensure that the conflict is properly addressed. It doesn't mean that that person can't engage in worker services for the Strata Corporation. They can certainly proceed with those services. However, if there's a breach of the conflict guidelines, they may have a duty to account. And in that event, they might find themselves losing any profits or remuneration. And so you need to make sure as a council member that you follow these strict guidelines under the Strata Property Act. And if you do, you'll find yourselves on solid legal ground and without any challenges regarding accountability. We'd like to talk about three different kinds of contracts. These are different contracts in nature and scope. First is the installation of fiber optics. A good example there would be TELUS. A second is elevator service contracts. And the third is the installation of communication towers. Now, we live in an electronic world, and in an electronic world, many of the fiber network type issues and communications networks are extremely important. And so these are coming up more and more frequently and will continue to do so in the future. So let's talk about fiber optics. We know that fiber optics is a high-speed internet type concept. It's speed of light, it's very fast. And so what do we need to do when we're considering having fiber optics installed for our strata corporation for the benefit of the owners and others? So the first thing you want to be doing is you want to identify who's going to be doing the installation. Who's the contractor? We want to know who that person is, and we want to know their background. So we are going to be recommending that you do an investigation. Again, only parties to a contract can sue or be sued. So you might find there will be a parent company that is very rich and fluid in terms of assets and money. However, if you have a subsidiary that you're contracting with, the subsidiary may not have any financial assets. In that event, in the event of a default, who are you going after? All you're ever going to get out of a corporation is you're going to get what the corporation has. If it has nothing, then the bottom line is you can't get blood out of a stone. And you can't go after the parent. Well, there's some very rare exceptions, but you're really contracting with a subsidiary and you find out it has no assets. And so really, in the event of a default, who are you going after? Someone that's judgment proof. So be careful. Who are you dealing with? What is their background, no matter who it is you're contracting with? And do they have the wherewithal in the event of a default to put you in the best possible position at the end of the day? Key thing, this is probably should be the very first thing you should do, is get a copy of the contract for your review. What kind of contract is it? Is it a contract that's a license agreement? Is it a lease agreement? Is it going to be an easement type arrangement? Is there an interest in the land, or is it just simply contractual in nature? Because the manner in which you'll have remedies is going to differ dependent upon the nature of the contract itself. Then you want to submit it to legal review. It's a very typical scenario where the cost of the legal review is paid by, and it'll be reasonable legal costs, is paid for by the person that wants you to enter into that contract. Now, in that scenario, you have to ask yourself, is there any downside to getting legal involvement in order to assist with the contract review? And the answer is absolutely not. There's so many pitfalls because you need to make sure that you comply with the provisions of the Strata Property Act to ensure that the Strata Corporation has a proper mandate by way of resolution, 3/4 vote or otherwise, to ensure you have a good contract. And so that has to be addressed. You need to look at what are we doing to install this component, and what is going to be impacted during the course of installation. Is it going to be the building envelope, the common property, portions of the strata lots or common areas? What areas are affected? And it really depends on what you're doing. So you want to be identifying those areas and then ask yourself who owns them. If they're common property and you're going to be putting an installation on the common property, well, that's one thing. The Strata Corporation and all of its owners own that land as tenants in common, and they'll be responsible. But if it's a rooftop and it's limited common property to the developer, and you're putting a major installation up there with revenues kicking out at 100 grand a year, then who's going to get the benefit of those revenues? If it's limited common property, then that's for the exclusive use and benefit of the owner of that particular LCP. So you should be asking, who's getting the benefit, the developer or the Strata Corporation? So you always want to be looking at your strata plan and asking yourselves, what land is affected? How is it impacted? And what should we do after this? You look at the method of the installation and how that will impact these particular areas. There's going to be issues regarding access to the building. Are you going to be giving access to the entire building or portions of the building, and to common rooms and just some or all of them? And then how do you get the fiber optics from the street into the building itself and then to each unit? Which electrical rooms or mechanical rooms are going to be involved? Then you have to ask yourself, do we have a proper mandate? Because we want to ensure that we're standing on solid legal ground. And you may need a 3/4 vote of owners. And there's a number of cases where that's required. But I think the rule of thumb for today is that you need a proper mandate. You will more than likely, in all probability, need a 3/4 vote of owners.
Cora, one of the issues that's been coming up on the fiber optics installations, and it's from all of the companies, and everyone should watch for this, is what's happening is they're getting a proposal from the companies, and then they're approving and authorizing the proposal. And then once the work is started, somebody pitches up with a contract for the strata design. Nobody's questioning it. And
Right.
and you know, don't approve a proposal. The proposal will be wonderful in helping in the decision-making process, but before you agree and have a final final contract arrangement, get a copy of the complete contract that's being proposed for the services, and review it and have it reviewed, and find out who the terms and conditions are. And if the contractor who's wanting this service to be, you know, added to your building is not prepared to pay for your legal services, then you really should start asking questions.
I think that's really good advice.
Yeah, proposals are not contracts, and people really should not confuse the two.
Excellent point. And an agreement to agree, just like you have said, is not a contract. So let's talk about the terms you should be negotiating if you're entering into this agreement. And again, a proposal is just that. It's a memorandum of understanding. This is something we can do, but we haven't agreed upon it yet. An agreement to agree, a proposal is not a contract. So what do we need to negotiate to make sure that we have a proper contract? And I'm going to review them again, and you'll hear me do this at the end of this seminar, this webinar as well. Offer, acceptance, consideration, certainty of terms, and a dispute resolution clause. That all sounds very simple, but then you start to get into the complexity of it all once you get into the nuts and bolts. So again, identify the parties, investigate the background, financial and otherwise, as I pointed out previously. What's the nature of the agreement? Is it a license? Is it a lease? Or is it an easement type arrangement? What sort of approvals do you need from the owners in order to make sure that it's properly approved, legally valid, and enforceable? So you need to have a 3/4 vote is what I'm going to recommend almost as a rule of thumb in every case. There could be exceptions. What's the scope of the contract? What's the term? Now, the term is extremely important because if it's a short-term contract, if it's a year, then that's very short term. But if it's 25 years with automatic rights of renewal, you're likely looking at a disposal of an interest in common property. And that's where you'll probably invariably need a 3/4 vote of owners under the legislation. And so what are the rights, duties, and obligations of the party? Rights of access, rights of repair, rights of maintenance. What about disposal and replacement? Who does the work? When's it done? What about emergency circumstances? What items are covered and which items are not? And then we get into issues, especially with these fiber optic contracts regarding requests for exclusivity. And you might get into restrictions in terms of competition, and that could violate certain legislation, CRTC. And in that event, it might not be appropriate to have exclusivity clauses. In other words, you can only use TELUS, but you can't use Shaw or some other service provider. So you want to be careful with contracts that do that. And then you want to be asking yourselves a number of other questions as well. What are the representations and the warranties? Do you have authority to enter into the contract? Have you done your 3/4 votes? You should have a checklist. What about insurance obligations? Have they been properly put in place? Liability insurance, other things. Indemnity provisions. What happens if something goes wrong? Who pays for what? Is the Strata Corporation indemnified in the event of defects? I'll get into more detail on insurance provisions dealing with elevator contracts and other type scenarios. And termination provisions. Some contracts that have been proposed do not have proper termination provisions. In other words, you don't have an automatic right to terminate for cause. You may be able to give notice that you're not going to renew before the end of a 25-year contract, but it may turn out at the end of the day that you're simply not satisfied with the contract, you'd like out, but you don't have proper termination provisions, and then all of a sudden you might find yourself locked in and unable to get out without a lot of trouble, cost, and legal expenditures. What happens in the event there is a dispute between the parties to the contract? How do you resolve those? Is it arbitration or some other adjudication? What are the rights and remedies in the contract itself? Have these been properly covered off? And if they have not, the concern is that if you don't have a proper dispute resolution clause, you may not, in contract law, have a valid and enforceable contract. You've got a defect in the structure of your contract. Contracts, when you draft them, are an art. You have to make sure you do them properly. Elevator contracts. Now, this is interesting. We have an elevator in the building. The building is 3 stories high. So if the elevator goes down, even though we've got an aging population, it may not be earth-shattering if it takes a long period of time to repair or fix or replace that elevator. But if you have a 20-story building and you've got 3 elevators, and you need those elevators with your aging population or any population to get in and out of the building, then making sure those elevators work and work properly is a really key issue. In fact, what happens if when you're putting the elevator in to the building, because you're replacing it, how do you get it in? Do you need a crane? If you need a crane to pick that elevator up and then install it, what happens if the crane collapses? We know we've seen this where people have died as a result of that. What happens if there are other mishaps? How do you deal with that from a liability perspective? So what could possibly go wrong? Many things have gone wrong. That's why we have this wealth of legal cases. Every time we turn around, there's a new one. So there could be accidents, there could be injury, there could be damage to the property itself if the crane falls. It could be personal liability if a person is killed. So that's damage to property and to people. So this really underscores the importance of making sure you've got proper liability insurance and, of course, a construction insurance and other insurance to mitigate against these types of risks. And to make sure that all of the named insurers are placed, or insureds are named on the policy so that if the policy is triggered, that you can go and deal with it accordingly. So what happens if the scope of work isn't properly conducted? We know that we have to replace the elevator, but in fact, the work was never completed, or it's late, or it's taken months as opposed to weeks or days. So what happens then? Do you have any performance provisions that are triggered in the event that the work isn't properly done? And then once the elevator is already in, how are the payment for services provided? Are they paid on a monthly basis or are they paid on a quarterly basis? And what does it cover? Does it cover the service component, repair, maintenance, and replacement of certain components? And if yes, what components are excluded? There's a number of components that might not be covered. They might have the major electrical and the mechanical components covered in terms of the service agreement itself. But there's a number of things such as elevator equipment that could be excluded. I can go through about 10 things that possibly could be excluded that are very expensive components in the event that you don't properly address them. So you want to be looking at those particular issues and making sure the service portion and the repair and maintenance coverage portion is suiting your needs. Who's supervising and managing this elevator contract? How is that being done? Is it being done properly? And this is administration. So those are questions that you really want to be looking at, not only when you're doing your contract at the get-go, but as you go along throughout the course of the contract itself. What materials and services are included? I just addressed this. There is a checklist for elevators that you definitely want to go through, and you want to be looking at what's included as far as repair, maintenance, and replacement of equipment is concerned, and that's your machines, your motor rotating element, it's the control equipment, your governors and things along that line, and hoists and hoistway equipment. All of that should be looked at. Is it covered in the service contract? How long does it take for these people when you call them to respond? Are they just going to be responding from Monday to Friday from business hours? What happens if the elevator goes out of service over the course of a weekend or on a statutory holiday? Have you covered it off in your contract as to what the cost is going to be to get someone in on short notice outside of the hours in the contract. Is it going to be time and a half? Is it going to be double time? Is it going to be much more than that? So what are the after-hour call times and response times? And what's it going to cost you to have all of that done? And then, of course, in the event that you want to get out of the contract, are you able to do that? Are you able to get out for cause? What are the termination provisions? And can you actually terminate a contract and bring someone else in because you're not satisfied with the manner in which the contract is being carried out? What's a reasonable term for an elevator service contract? Is it 5 years? Is it negotiable? Or is it 15 years or 20 years? And how are you going to be able to renew or extend that term? Is there a right of early termination for cause? Is there an ability to say, I'm not satisfied with the services you're not providing. I want to get out of this agreement. And can I terminate on that basis? Can I warn you? What are the terms and conditions? And many times the termination provisions are not thought of at the time when you're happy to get your elevator in, but they become important as time marches on. So what components are part of the service contract and which ones are going to result in additional costs? This is where you need that checklist, as I pointed out earlier, and you want to closely detail and itemize and analyze all the various components. That means you need to know what those components are to compare those components to what's in the actual contract to see what's missing. It's a process, and it can be daunting and it can be arduous, but this is something you need to do to make sure that the Strata Corporation and its owners are properly protected.
Cora, I was going to say that this is one of the areas I think that there is a lot of confusion around. Bernard from the Okanagan asks a really great question here is, do you need a 3/4 vote to approve a 5-year, 10-year, or 25-year contract because you're binding the corporation into this, especially when your annual budget just is simply that, a 1-year term for approval. What happens if the corporation doesn't approve the annual budget? Or, what happens if there is an amendment or alteration? Like, the corporation has essentially committed themselves into this. And we have seen in the past year, elevator contracts that are 25-year periods. I would never, ever sign a 25-year contract.
Yeah.
You want a contract that you can control, manage, a term that's reasonable, and gives you the ability to get out of it and cycle. But it is a really good question, in the terms of these contracts.
Yeah.
Do you need a 3/4 vote? Historically, no one has done that. But I don't know if that question has actually been put to the courts or to the tribunal.
Yeah, and here's the question. I'm going to rephrase it slightly. When you have a contract, which is a 25-year contract, and in the elevator agreements that I've been asked to review, I can tell you that it was a 25-year contract with the right to renew for an additional 25-year term or terms. So it means that you're looking at 25 years plus another 25, so that's 50 years plus another 25. So you've gone beyond what we would typically expect for an elevator type contract. However, having said that, the question is, when do you, under Section 80, subsection 2 of the Strata Property Act, require a 3/4 vote? And the answer is that you require a 3/4 vote when there has been a disposition of common property. So the question becomes, what is a disposition of common property? And the answer is, the longer the term of a contract, even though it's not granting an interest in land, the longer that term is and rights of renewal and restricted termination rights, the higher the probability is that you're approaching what I would characterize as a disposition of common property. And so I think when you've got a long-term contract like that, and even if you don't, I would still like to see a 3/4 vote of owners under the Strata Property Act. And how do you deal with annual expenditures for these contractual obligations? Well, we know you would put something like that into the budget and the owners would pay for that through the strata fees. So no question about that. And there's a lot of uncertainty. You might find that there are annual increases to the amount that's payable in terms of remuneration under those contracts. It could go up at the rate of, say, 4% a year, or whatever's cost of living or whatever's been negotiated. So you're not just going to be hit with whatever the annual amount is, you're going to be hit with the annual amount plus. You have to look at whether or not there's any extras in the contract, what equipment isn't covered, and then take a look also at the service costs. So when you're negotiating a service agreement, one of the things you could do is you could indicate, look, I'll pay you more. I don't want to have any extras. I don't want to find out at the end of this day that I'm not going to be paying $10,000 a year for this. I'm going to be paying, because of all the extras and the work that's done on weekends and elsewhere, $20,000. So the best case scenario for me is I want to negotiate, if I can, I'm not guaranteeing you can do this, a fixed price for service all of the time. And then as opposed to paying $20,000, you might end up paying $15,000. And that's what you would try to do, is hedge your bets, mitigate against the risk, and try to come to some compromise regarding certainty. So those are the kinds of things you can do when you're negotiating a contract. I'm not guaranteeing you'll be successful, but it's one of the things you could do. Now, if you don't have a 3/4 vote of owners and one is required, clearly a lease or an easement, at least longer than 3 years, well, the topside decision, Court of Appeal decision, comes in and says that that's a subdivision, so you're into a whole new ballgame. Be careful of that. It could be void. And lastly, if you're dealing with an easement, you have to have a 3/4 vote because that's a disposition of land. So there's no question that qualifies. And licenses are a little more complex. So at the end of the day, seek legal advice, but err on the side of caution, get the 3/4 vote. What have you got to lose? Also, if you've got a bulk services contract, you'll need a bylaw anyway, so bulk them together. If there's a significant change in use or appearance of common property under Section 71 of the Act, throw that in too. So then you can mitigate against all of these concerns regarding whether you have a proper mandate or not by having the proper resolution in place and approved. And that everybody knows it was properly approved and that payment has to be made. This is a third-party obligation. And so it's included in part of the budget. You could, if there's a concern, put it in the bylaws to require the amount to be paid on an annual basis. You've always got ways to use that 3/4 vote to your benefit. Whether or not you need all of that or not is something the lawyer can assist you with at the time. So what components are part of the service contract and additional costs? Again, have a very clear list and go through all of that, and a checklist to make sure you knock off all of the issues that need to be addressed.
So just one more follow-up question, which I think is really great that's been raised, is, are performance bonds for elevator contracts appropriate? And our experience has indicated that the elevator companies won't provide them, so they won't enter into them and get and provide them. What you do need, though, is you need performance conditions within your contract. In the event the following conditions for operation of the elevators, service within the time periods, callbacks within the time periods, in the event these conditions are not met, here are the following penalties. And penalties can be things like forfeiture of 1 month's worth of operations fees, or termination of the contract under certain circumstances. So no, absolutely, maybe not necessarily performance bonds, but performance measures that directly link to consequences in the event that the services are not fulfilled.
And that's a really good point, because in the absence of performance conditions, then, and that should be in the contract, it should be in writing, then you may not have the clout to compel a service provider to meet the terms of the contract. So you do want to have those clauses in there, but the key point is you need to draft them, negotiate them, and incorporate them into the contract so that they apply when you need them. So I think we just go to the next slide. So let's talk about the installation of communication towers. And I've got to point out here that these communication towers can kick out a tremendous amount of revenue annually, anywhere from $25,000 to $100,000 a year. Of course, there's GST and other things that could be triggered, but there's an increasing demand for these communication towers, especially on high-rise buildings, because they permit communication. And that's the age we live in, the communication age. So if you've got a high-rise building and this tower is placed on the top of your building, then everybody wins because it allows the communication to take place. And also there's revenue coming back to the Strata Corporation. So this could be anywhere from a major change to a minor change. And we're going to show you a picture in a second just to show you, and I'd like to actually go there now because I'd like to show you what this might look like. Here's a building, and at the top of the building, you're seeing what is a very significant tower. So you've got to ask yourself, how big is this building? Well, it's obviously a multi-story building, and it would be high because the higher the better for the communications contract. So you can see, how do you get it up there? You don't just walk up with the components through the elevator. You're probably going to need a crane, and you're going to have a significant amount of work done just to get that tower up there. So once it's up there, it has to be repaired, it has to be maintained. So that means that people are going to be walking through your building in order to access that area to conduct whatever repair and maintenance is necessary. And also it's taking up a very significant portion of the top of this building. This could raise a number of questions. Is this building capable of structurally supporting the weight of this tower? Have you done all of the due diligence to make sure that everything is done the way it should be done? And then what happens if it isn't?
Did you want to go back or forward?
Let's go forward. There's so many questions that will come up with communication towers. Obviously, offer, acceptance, and consideration. How much are we going to get? And then you want to be asking yourself, do we have certainty of terms? Have we covered off insurance? Have we covered off termination? Have we covered off dispute resolution? Have we covered off a number of different things? And so you have your checklist, just like we've talked about on all of the other contracts. The list is the same. What changes is the nature of the subject matter. And so you ask yourself, what is the subject matter? And then you draft your contracts accordingly. But there's another aspect to all of this that we may not have thought about. What's the scope of the access to the roof? Is it 24/7? Is it just during work hours? And what access? Are they able to close off elevators going to the top of the roof? Is it going to impact people in the building? How will it impact them? And how do you deal with that? What about health and safety implications? What happens if the crane fails? What happens if there's loss or damages? And window washing. How do we deal with that, knowing that there's an easement that's been granted to another party? Are we able to use a portion of an easement area? Because you will have an easement. What an easement is an easement is a right of use of a portion of the common property that's pursuant to an easement area designated on an explanatory plan. And this document is approved by the parties as part of the terms and conditions of the easement and filed in the Land Title Office. So it's typically in perpetuity. It runs with the land. There's a number of terms and conditions, but you want to make sure that the easement addresses the issue of access and addresses the issue of use of those portions that are used jointly by the Strata Corporation and the grantee. So there's a number of issues that come up. And so we need to ask, how's major construction going to take place? And how will this impact the owners? When is it going to be done? Is it major construction? And what happens if there's a change? Who's responsible for those costs? So just like if you're dealing with a major repair project, you want to make sure all of these terms and conditions are covered off because there's phases to this. The first is the installation of the tower itself. And there's a lot of issues related to that. And then there's the repair and maintenance thereafter. And the terms of the contract and the easement will govern those items. Are these revenues that you get, 25,000, 100,000 a year, are they taxable? That's assuming that these revenues go to the Strata Corporation. And we know that Strata corporations are not-for-profit corporations, so they're not taxable. but they still have to file tax returns annually. Some of those revenues could be taxable, but we do know one thing for sure, all of these revenues have to be reported. So you need to make sure that you seek appropriate advice. What lawyers do is lawyers give legal advice. We don't have under our license the ability to provide financial advice or to appraise properties, for example. Those are done by people with specific talents. Our job under our license is to give you legal advice. So this is a scenario where you'll probably want to go and seek some advice from appropriate financial advisors and others dealing with your accounting. Is a 3/4 vote required for the installation of this communication tower and the relays? And the answer is an unequivocal in this case, yes, because of the nature and the scope of the project itself and the requirement for what I would characterize as an easement. And clearly this is a disposition of property under section 80 subsection 2. So a 3/4 vote is required. You do need to have, because we provide legal services, a qualified lawyer to prepare those documents to make sure you're standing on solid legal ground. The principles of contract are clear. And the minimum standards, again, are offer, acceptance, consideration, that's usually money, or it could be peppercorn for a buck, for a Rolls Royce, peppercorn for a Rolls Royce, certainty of terms, so you need to know what you're dealing with, and dispute resolution clauses. Again, an agreement to agree, as we pointed out earlier, a proposal is not a contract. You need to do due diligence and do it properly. And so thank you very much, and I'd be happy to answer any questions.
So we've been doing them as we've been going along, so that's kind of saved us a little bit of mileage here. One of the questions that, and this has been a frequent question that's come back to us, it's fine to say we need a 3/4 vote before we enter into an agreement to install fiber optics, but what if the Strata Council already provided consent and the work has already been underway and they did not get a 3/4 vote?
Well, the problem when the horse is out of the barn is you've got to take mitigation steps to try and get the horse back into the barn. So it's always better and easier to do it at the get-go at the beginning. But if you haven't done it that way, then one of the ways to put yourself back on solid legal ground is to go for a ratification vote and a 3/4 vote and approval of the owners at a general meeting. Well, is that a cure-all? Well, what happens if the vote doesn't get approved? There's a risk. And if the vote doesn't get approved, then where do you stand? And the recommendation there would be you want to be looking at hiring your legal counsel to provide you with a legal opinion regarding the nature and the extent of the problem and how to mitigate against it.
So, you know, on the same vent, the question here is, TELUS has offered to bring the fiber optics program into our townhouse complex at no cost. Well, of course, it's no cost. But the bigger issue is, and the bigger issue is, do they still need a 3/4 vote because they're a townhouse complex? The answer is yes, because they're going to be using common property to access all the townhouse units.
Bingo.
Yeah, like there's no way around it. And, you know, I would think for a Bearland strata, it might be the same consideration because it's quite possible that they may be using the common areas of roadways or access to be able to, again, to bring fiber optics to each of the residences. I think you really have to ask where this is being located, how it's located, but the town, you know, townhouses need to remember building exteriors are still common property. There are still building envelope issues to consider how these are being installed. And we have definitely seen, and you know, the other side of this, it isn't TELUS who's doing this. It's a subcontractor who is doing this as contracted by TELUS, right? So it's not TELUS that's coming along and doing this. It's the subcontractor who's contracting the service for TELUS. And we have seen some building envelope damage that has resulted in costs for the clients because the terms and conditions and how it was addressed weren't detailed properly. So, you know, exercise prudence, and yes, you still need a 3/4 vote before you go any further.
Best practices is get your mandate in every scenario Make sure you've covered off all of the requirements under the Strata Property Act. Get legal advice, and especially if it's paid for by a third party, why wouldn't you? And then make sure that everything is done properly. It's a process.
Yeah, and just a little follow-up question to that. When it comes to fiber optics, for many of the companies, we're targeting TELUS, but it's not TELUS, it's the subcontractors, and it's any of the companies who are doing this work. The question is, why is a right to enter agreement not sufficient? Well, the right to enter agreement is granted after the Strata Corporation has passed a 3/4 vote.
Right.
Right. It's
Right.
not about, it's not that it's not sufficient. It is certainly sufficient and applicable, but it's the sequence of what's necessary to be able to do this.
Right.
And I think that's the part that for strata corporations. How are we for time? We're close. One more question. So, and the other question is, do you recommend the use of CCDC documents and general conditions of contract? Well, I'll comment real quickly because I'm involved in some incredibly major construction right now,
Right.
that there are a variety of CCDC documents that are available depending on the relationship and the terms and conditions. Some contracts, this might be an appropriate document. Generally, it's not necessary for smaller service agreements, smaller contracts, but the implications of what the liabilities may be most certainly could require the use of construction standards documents.
I agree with everything you said.
What? And nothing to add?
Well, I could go on for a very long time about those contracts, but in a nutshell, the answer is sure, you could use them if the circumstances are appropriate.
Right, right. Okay, so I'm going to just tackle one more here with respects to the a bare land. TELUS are putting fiber optics in the area of the strata, and have asked that the strata sign a right of entry agreement. Is a right of entry agreement necessary? Well, I think for a bare land, there are going to be two separate agreements. I think the first is the strata will have to pass a 3/4 vote for right of entry on common property. And then with respects to the individual strata lots, each strata lot owner is going to have to provide consent.
Yes, I think that's right. And I just want to point out what the difference is between a building strata and a bare land strata. A building strata is when you stratify the units, such as a townhouse or an apartment. So anything outside of that unit is common property. Bare land strata is where you take the land itself, fracture it out into pieces, and then the strata lot itself is the land, not the building. So that's the difference between, in a nutshell, bare land and building strata. And so the building on the bare land is built by the owner, and the owner is responsible for the insurance on that building. So when you are looking at bringing in fiber optics into a bare land strata, the only thing that the strata corporation is concerned about is the roadway or the common property areas where you're going to have that particular installation. So common property ends at the boundary line on the land of the strata lot. So thereafter, the owner will come in and take over responsibility.
Exactly. Cora, thanks so much for pitching in at the last minute and helping us out. That was just super. I just want to acknowledge and again thank BC Housing for their ongoing support of all of the research that they do and all of the program development that they do with us. Tribe Management, thanks again for your sponsorship. All of these makes all of these events quite possible. We are going to be posting some additional bulletins to the website this afternoon, as well as the PowerPoint. So you'll be able to see it. It will be the YouTube channel from where we officially started the seminar at the beginning at 12:01 up to this point. And there is an information bullet article that we sourced out, and that was a staff person at BC Housing referred us to, that is excellent, about the risks, health and physical risks of communications towers on buildings, that we're also going to be posting to the website. So check later this afternoon, it'll all be posted up there. The other thing is, if you haven't had a chance, go to the website and do the survey that we have underway right now, because we are participating with government on a number of fronts of potential legislative amendments. So everybody, every staff person in every office, management, strata councils, owners, get everybody to participate in the survey. It really makes a big difference when the numbers are there with respect to government. So thanks again very much, everyone. We got to everybody's questions. I'm so glad about that. And we will stop and then we will see everybody at next week's seminar, which is winding up a Strata Corporation. So talk to you soon and bye for now. Thanks, Cora.
Thank you. Bye-bye.
Bye-bye.